Chapter 9. This is how many chapters now are we into contracts? Let's see. Is this the third one? Yeah. So we've got the elements down. We know what a contract is now, ACLAF, right? We know what the elements and major defenses are. Now in Chapter 9, we turn our attention to other people's rights. Do people other than the ones entering into the agreement have any rights in the contract? So that's what we call third-party rights. The third wheel, you know. You ever go out on a date with somebody and they have to have a third wheel, and it's like, go do your business. We got things to discuss. All right. That's what we're going to talk about here, except nothing nearly so romantic. So third-party rights in contracts. Discharge, which is in terms of how does the contract end. We have a good contract in place. Now, when does it over with? Ways to discharge it, there are 5. And then we're going to talk about, in particular, specifically, breach of contract. When does that happen? Frequently. And remedies, which is what happens when we breach. How do we get back to normal? What is the legal remedy that comes into place? Remember, the importance of knowing all of this and studying all of this is so that we can predict it. If we can predict it, then we can plan for it in business, and we can make contracts that are, number one, good, solid contracts, and number two, they make account for the possibilities that could take place. So first we look at third-party rights. The first way that we look at a third party getting some rights in the contract is by giving them rights in the contract. So we call this process assignment. And here we have A and B, and they enter into a contract. And let's say the contract is for A to pay B to do something for him. And so the question is, if A assigns his rights to C, can B, the original contract party, say, no, I'm not going to do that for you. I promise to do that for the other person. So an assignment is a transfer of contract rights to a third party. Now I'm just going to preview this and come back. The other thing that could be a possibility is transferring the duties, right? The rights and the duties. So those are the two things that we're kind of comparing here. In an assignment, let's use an example of a loan, okay? So if Alex up here loans money to Brent, what are the rights and responsibilities now at this stage of the contract? Brent has a duty to do what? Make payments, right? What is Alex's status at this point? He has rights. We don't call them duties because it's not a duty to accept payments. It's a right, okay? It's a good thing. I'm going to receive this money. I'm getting the benefit now that I have paid for. I've given him the money originally, and now he has the responsibility to pay me. Now, what if Alex, who's going to receive, how much should we, let's say we loaned $1,000 to Brent. $1,000 is a lot of money. And so Alex loans $1,000 to Brent. Brent now has to pay it back to him. And let's say it's a short-term loan. He's going to pay it back to him on Friday. Okay, so it's just a short-term loan, $1,000, one payment, one time, 1 week, no problem. Okay, so Alex, going along in life, and all of a sudden he meets Carmen, and Carmen says, hey, I heard you're short on cash. He says, yeah, I gave everything I had to Brent. And she says, all right, well, I'll loan you $1,000 if you will assign to me the right for Brent to pay me back instead of you. All right, little algebra here, okay? But A plus B equals C or whatever, all right? If A equals C and B equals C, then A equals B, right? And that's what we're kind of trying to do here. And so Carmen says, why don't you just assign to me the right to receive the payment from Brent? Now, that's a nice, clean, fair arrangement, but that's not really how it happens in the business world. You know how it happens in the business world? Carmen says to Alex, Well, it's a shame. Let's say Alex all of a sudden on Thursday, after giving all his cash to Brent, needs a car repair. And he doesn't have any credit cards and he has to pay cash, right? And so now he needs money and his car repair is $800. Oh, I wish I hadn't given my $1,000 to Brent. And he's not going to pay me back until too late. All right, well, what am I going to do? And Carmen comes along to save the day. And now Carmen's deal is, I tell you what, here, Alex, I'll give you the $800 you need if you assign to me the right for Brent to pay me back the $1,000 you owe him. He owes you. So now Carmen is kind of like a loan shark, right? And so she's going to make $200 off of this deal. She's going to pay Alex less than Brent's going to pay her. That's the business. By the way, those businesses are all over the place. It's called the secondary market for instruments. In Law 2, we're going to talk all about negotiable instruments and how that process actually takes place. But the prime example of it is it's an assignment. Is that legal? Sure. But here's Carmen. So Carmen, now it's Friday. Carmen has this little, napkin, I owe you $1,000, that kind of thing. And so now Carmen goes to Brent and says, she sees him walking over to Alex's house, and she says, hey, are you going to do it? You got your payment? Yeah, I do. I'm going, but I owe it to Alex. And she says, oh, no, you owe it to me now. And Brent's going to say, what? Whoa, hey, I don't even know you. How could I owe you $1,000? I don't even know you. I've never seen you before in my life. So can Carmen enforce legally the rights that Alex assigned to her? Yes. In fact, that's business. That happens all the time. That's very frequently done in the business world. When we purchased our house, the very first house we bought in Florida, we carefully researched which bank we wanted to get our mortgage with. We wanted a bank that had online options. Back then it was pretty rare. We wanted a good reputation. We wanted it to be around for a while. We wanted to get a good rate. And so we went with the bank we really wanted to deal with. 1 week after the closing, we got a letter in the mail that said, we sold your loan to, whoever, some loan processing company I never heard of in New York. And it says, no longer send your payments to us, send your payments to them. They own your loan now. What? I didn't agree to this. I wouldn't have to. That's the key. Brent doesn't have to agree to this. It's between Alex and Carmen only. So that's an assignment. When the right is the right to receive payments, all right, when the right is the right to receive payments, and that's not always true because other kinds of contract rights can be out there. But when it is just the right to receive payments, it's almost always going to be upheld. And here's kind of an interesting thing. Even if there's a no assignment clause in the contract, because it's so fundamental to business and it's so common and it's so common sense that it doesn't matter. There's nothing unique about where you send your payment. Let's try to contrast this a little bit. Delegation. Now, unlike assignment, delegation is the opposite. Under a delegation, Brent is the one that's giving away something to a third party. And the person he's giving it away to now has the requirement to pay the money. Not to receive the money, but to pay the money. So in this case, Brent turns around, takes the $1,000 cash that Alex gave to him on Tuesday, and loans the money to Carmen, who evidently, maybe didn't have as good a credit. So Carmen couldn't have gotten that loan from Alex, but Brent did. So then Brent, he's got a soft spot for Carmen. So he says, okay, I tell you what, I'll let you have this money. And listen, you don't have to pay me back. Just pay Alex back. I am, and here's the term, delegating to you the responsibility, the duty, to pay back to the original party. Now, this is a little different, isn't it? Because it's no longer about just the right to receive the money. Now there is a judgment call here about whether Carmen has the credit, whether Carmen's going to make the payment. And Alex there would have done a lot of investigating before he gave that 1 week $1,000 cash loan to Brent. So here we have a little bit of a different caveat. Can you do that? Yes. Nothing illegal about it. Definitely legally enforceable. There's an exception though. There's a but. Wait a minute. What's that? Good term here. Delegatee. It's like a goatee, but a delegatee. All right. Still owes the original party and is still liable for performance. What's that mean? Friday comes and Carmen, just because you know that's how she is gone. Totally departed for parts unknown. In our class, she always goes to Costa Rica, okay? Bad guys all live in Costa Rica in business law, okay? So she's out in Costa Rica, sitting on the beach, you know, with Brent's $1,000, you know, haha. She went on a dream vacation around the world with that $1,000. All right, might get you to like Huntsville. All right. So she goes all the way to Costa Rica with his money, completely outside the jurisdiction and gone. And so Brent goes to Alex. Well, sure stinks, doesn't it? Alex says, what? What do you mean? It's Friday. I'm looking forward to getting paid. Give me my money back. Oh, yeah, that's what I mean. It stinks. Neither one of us is getting paid. What do you mean by that? Well, I mean Carmen, you know. Who's Carmen? I gave that $1,000 you gave me. I gave it to her. She's supposed to pay back today, but she's gone. Alex says, I'm sorry, pal. I don't know any Carmen. I know you. You're the one I contracted with. You owe me the money. Can Brent get off the hook by delegating the duties to Carmen? Nope. He is still on the hook. So he might be what we call secondarily liable, where Carmen is first in line, but if Carmen fails, guess who's still back in line? Oh, rats. Yeah, Brent. So the delegatee still owes the duty to the original party in the contract and is still liable for performance. You know where this happens a lot is with apartments. And so maybe you have an apartment. This happened in law school all the time. Law school students wanted to rent apartments, but the lease was always for 1 year. But you're only in school for 9 months, and so then you get into the summer months, and people would want to back out of their lease contract. And they'd want to say, well, I want to pay you for a time I'm not even going to live there. And the landlord says, I don't care. You signed a 12-month lease. You owe me the money. I don't care if you live there or not. That wasn't the deal. Okay? The deal was you have access to it. You can stay there or not stay there. I don't care what you do. Well, they do care what you do, but doesn't matter to me. And so every May, all these law school students would be putting up flyers and going around like zombies throughout the law school. Hey, are you staying here this summer? Hey, man, are you staying here? You need a place to live? You know, and they were hawking apartments like drug dealers, you know, on the corner. And they were saying, God, it's a really good one, you know. And why? Because they're trying to get somebody else to delegate the payment, the lease payment to live in their apartment over the summer. So what if I say, okay, you know, actually I am going to stay here in the summer. I'm going to work. I'm going to do summer school or whatever. So I'll live in your place. What's the rent? It's like $650 a month. Oh, okay, I can do that. All right. So I start making the first payment, and then I say, you know what? This place has a weird smell to it. I'm not staying here any longer. This is weird. I don't like this at all. I'm leaving. If I leave, guess who's still on the hook? The original lease signer. That original signer that gave it to me. So a delegation doesn't take you off the hook. All right? Clear enough? Any questions about assignment versus delegation? Just keep it in your head. Assignment rights can always pretty much be transferred. Delegation, duties. Can be transferred most of the time, but doesn't take you off the hook. Now, there's one caveat I should point out. What if instead of paying money or leasing an apartment, Brent is an artist? He's a sculptor. And he's going to sculpt a sculpture for the Maranatha campus. We're going to hire this guy, and he's going to come, and he's going to sculpt Be Snarly. a saber cat. Wouldn't it be awesome? Right on top of the sign, big saber cat, sculpture, and we kind of give him a few sketches of what we want it to look like, and he takes on this responsibility. And Brent is a very famous sculptor of prehistoric animals, and so we did all our research, and he has kind of a specialty here, and this is the guy we want. And then he gets the job, and we agree to pay him thousands and thousands of dollars. I can put you down for at least 20 on that, right? You give $20 towards a sculpture on campus. Okay. Everybody, would you give $20 towards a sculpture like that? Say, probably not. They say, hey, I give you plenty. All right, I hear you. All right, so we raise the money, and we're going to pay it to Brent, and he's going to make us this wonderful beast gnarly sculpture on top of the sign. And Brent decides after getting the contract, signing the contract, I'm very busy, and I'm very sought after. And this saber cat thing, I don't know if it's going to be cool enough for me. I don't know if I want to do this. I'll just delegate this contract to, Joe Schmo down the street, right, who just started, with a chisel or a Dremel or whatever they use to sculpt saber cats these days. And so he just farms it out to somebody else to do that. When it comes to art, or what we call personal services contracts, which means it was personally relevant that it was you that were supposed to do it. When I was a student here, we got Reggie White to agree to come and speak to a student body. All right, so if you know who Reggie White was, he's passed away. He's a Christian guy. He's a great thing. And we were working with, as part of Student Body Council, Reggie White's people, all right, to get him to come here. He was a Green Bay Packer at the time, and it was like, this is going to be awesome. It was huge. The administration eventually told us we couldn't do it because evidently he's not Baptist enough or whatever. All right, so I understand that now. At the time, it really stunk. But if we had a contract, we never got that far, but if we had a contract with Reggie White and, like Joe Snodgrass showed up and he says, well, Reggie delegated to me to come and do your little speech thing. Wait a minute. You're not Reggie White. We want the man. And so when it's a personal services contract, those duties cannot necessarily be delegated unless it was specifically allowed in the contract. Okay? So just kind of keep that little caveat in mind when it comes to delegation. That's not necessarily applying to the assignments, but for delegation, that becomes relevant. Okay. So let's talk about third-party beneficiaries. Sometimes a contract between two people is really for the benefit of a different person. And the classic example of this would be life insurance, right? Think about it. I'm buying life insurance. I'm not going to be around when it's time to collect on the benefit of that life insurance, am I? My wife is the intended beneficiary of the life insurance. Makes sense. Now, if the law said, which the law, by the way, does say, only parties in, here's the phrase that pays, privity of contract, not privacy, privity of contract requires that you must have been a party to the contract in order to sue on the contract. All right, that makes sense. One of the ways for a non-party to become a party is through assignment or delegation. You step into the shoes of the original party, so you have standing to sue. But here, with a third-party beneficiary, we don't even have that argument to make, right? We don't have privity of contract. We were not a party to the original deal, nor was it delegated or assigned to us at any time. So we didn't step into the shoes of the party. So here we are, as a complete outsider to this deal, suing one or both or everyone in the contract to enforce the contract that we weren't a part of. And so legally, normally, the rule is butt out, right? Get out of this deal. This isn't for you. You cannot come in here with that claim. Normally, that's the rule. The only time that someone could sue to enforce a contract that they were not in privity to is if they were an intended beneficiary. All right, so life insurance is a great example of that. This chart, by the way, is in your book. An intended beneficiary is a third party to whom performance is rendered directly or has the right to control the details of performance or who is flat out designated as a beneficiary in the contract. Life insurance is a good example. What about an incidental beneficiary? Let's say they're going to build a high-rise in New York City. And it's going to have 100 apartments and 100 office suites for new businesses. Are the taxi cab drivers in New York going to benefit from this new building? Probably, sure. More people to take around, more people to take to the business. But are they who this is about? No, they're just incidental beneficiaries. So the example I like to give here is Watertown's 4th of July parade. You know what I'm talking about? All right. How many of you have ever been to Watertown's 4th of July parade? Most students don't get to go to this because it takes place, ironically enough, on the 4th of July, okay, when we do not have classes as much, okay? It's a wonderful time of the year, actually. In Watertown, they have an outstanding 4th of July parade. It's mostly tractors, but we also have polka bands, so that's awesome. And at least 4, and an Elvis impersonator. So you don't want to miss, you don't want to leave too early because Elvis is coming. Last year it was very depressing because he was singing In the Ghetto by the time he got to where we were at in the parade. And I thought, this is a horrible song for a parade. So, I mean, something better, anything. Ain't nothing but a hound dog. I don't know, whatever. So the parade is coming along, and the route is always announced ahead of time. And so those of us that live in Watertown, we watch carefully to make sure, because every once in a while they adjust it, and we watch carefully where's the route. And so let's say we run, what's it called? Schuett's ice cream stand. You know where that is downtown? Little ice cream stand. It's not open, during the winter months, but down there. And this year the parade is going to go all the way down past our ice cream stand and turn left on like Dewey or something like that, way downtown. Well, do you think that's going to benefit our ice cream stand on the 4th of July when it's 100 degrees out and all of these people are going to be right outside our store? Sometimes the parade route goes only to 4th Street and turns left on 4th Street before Schuett's, like 2 blocks before Schuett's. That's like feast or famine, right? So let's say the parade committee enters into an agreement with a promotion company to do the parade route all the way down to Dewey, and it's going right past Schuett's. And so Schuett's gets the announcement. They ramp up their hiring to make sure they have enough staffing. They order product to make sure they have enough ice cream on hand. It's perishable, so they got to get it just in time. They've got extra hot dogs and corn nuggets or whatever else they sell there. And they're really ramped up for big business. And the day before, July 3rd, it's announced, there's a lot of potholes on Dewey, so we decided that instead of going down there, we're going to turn on 4th Street after all. Schuett's is devastated. They're saying, wait a minute, anytime it goes down 4th Street, we sell almost nothing. This is terrible. We can't do this. You're killing our business. And so they go to court and they file an emergency petition for a restraining order to enforce these two, the City of Watertown and the parade promotion company, to put the route back the way that it was supposed to be. So you got to ask yourself, if you're the judge in that case, was Schuett's an intended beneficiary or an incidental beneficiary? Were they going to benefit? Yes. We're not saying they weren't. But the only way they have a case is if they were an intended beneficiary. Because if they're incidental, they cannot sue to enforce any of the terms of the contract. That's why it's important to know the difference. Now, in that case, what would you say? How many say they were an intended beneficiary? Anybody will make that case? All right, me neither. They were definitely incidental to the contract. All right. Discharge. So there are basically the rest of the chapter we're going to talk about. There are 5 ways that a contract ends. We won't get to all these today. But I want to start out this, and this chart also in your textbook. We're going to talk more detail about each one of these. But the 5 ways are performance, breach, operation of law, failure of a condition. There was something in the contract that said if this happens, we're done. Okay. And agreement. We just agree, you know what, this isn't working, let's walk away. All right, so those are 5 ways, categories that this can happen. I want to start by saying performance is far and away how the large majority, most contracts conclude. By far and away, performance is the number one way that contracts are discharged. Now that's something to remember, because for the rest of like 3 chapters, all we're going to talk about is everything that can go wrong. Okay? And I don't want you, because of that, getting all cynical, thinking that that's the only way, it's not worth getting in any contracts because they're all bad. No, most of the time, it works. And everybody does what they're supposed to do, and everybody's happy. Most of the time. Most of the time. It's not going to seem that way in about 2 chapters, okay? Because there's a lot that can go wrong. But most of the time, contracts are satisfied by complete performance. So when we talk about performance, the common law, which is where we're at right now, we're talking common law. The common law said perfect performance is required. So if the contract was for 500 blue racquetballs and there was 1 red racquetball in the group, we did not have perfect performance. Right? And the guy could say, listen, it bounces the same, it spins the same, it has the same crush test rating, the same materials, it's just dyed a different color. It's the same thing. It's close enough, isn't it? Under the common law, complete, perfect performance was required. Okay? Now we're going to find out later on under the Uniform Commercial Code, when we get to that part, like next chapter, that this is an area they've modified. Because the other possibility is substantial performance, where we say, well, there was a minor breach, but they didn't do it on purpose. They did it in good faith. And it didn't destroy the whole value of the contract. There was a case actually here in Wisconsin where coal delivery was the requirement, and they wanted 100 cars full of coal every week delivered, like clockwork. And for a while, this is Wisconsin Electric, needed this coal for their plants. And for a while, the company was delivering 100 cars a week, like they were supposed to. But then one week, they only delivered 87 cars. And they said, it's all we can do. We had an issue at the mine, and it's all we could get to you this week is 87 cars. By that time, Wisconsin Electric basically had found another supplier and wanted to use that to get out of the contract. So they said, well, 87's a lot, but 100's what we needed, and so you're in breach. We're canceling the contract. The coal company tried to argue substantial performance. So the issue in the case was, is 87% performance good enough? Is that substantial performance? And the court said yes. But they also said, but you're still in breach. So it's substantial performance, but it's not perfect performance. And if you wanted perfect performance, you would have had to be required. Now, we'll get to in a little bit what the remedies are. The remedies are a little different because you have to ask yourself, is the remedy 100 more cars? No. The remedy is 13 more cars, right? Fill the rest of the order would have been it. Now, there's another kind of contract here, satisfaction contracts. Sometimes, and these are kind of sticky, sometimes the contract will say, to the satisfaction of one of the parties. So if we were getting a sculpture done, we would say that this has to be done, Beast Gnarly has to be carved out, and it has to look like Beast Gnarly, and it has to be cool enough that we are satisfied with what you came up with. when we had the mascot costume made, okay, that's what we did. And we went back and forth with them 3 times on that costume. Why? Because he kept coming back with just the mohawk, and we said, no, it's not. It need to be fuller, like a mullet in the back. We got to get more hair, And so we kept sending it back and sending photos and 3D images and renderings, and they finally figured out, and it's perfect. It's awesome. And so, you have to go back and forth sometimes. That back and forth is called a satisfaction contract as you're trying to work that out. Okay? So what about breach of contract? That's performance. Performance requires perfect performance. A breach of contract happens in a couple of ways. One way is you didn't get the job done. You didn't do it. Performance was not substantial. If that happens, the innocent party can walk away. They can void the contract, or they have choices. They can sue for damages. And we're going to find out later on. Every one of these, by the way, we're going to talk about in glorious detail for the next couple of weeks. We're going to find out that in some cases, if it's a minor breach, like that one little red racquetball that snuck into the lot, then we have a chance to cure that. That's a legal buzzword that we're going to talk about. We have a right to fix it, okay? The other way that a breach can take place is anticipatory repudiation. There's a fun term. You can throw that around in your dorm room free of charge, okay? Anticipatory repudiation is where somebody calls you up and tells you, yeah, I'm not going to be performing that contract. Yeah, you know what? We decided to get out of the racquetball business, and so we're not going to be doing that anymore. What? What do you mean you're not going to do that anymore? What happened? And that's exactly what happens sometimes in contracts. Somebody will call, say they're not going to perform, change their mind, and try to hold you to it. Can they do that? Well, we're going to find out in more detail later on how it works, but the answer is no. Once you communicate to the other party in clear enough terms that you are not going to perform, then that party can consider you in breach, even if the deadline hasn't yet come. It would be like you coming up and telling me, listen, Dr. Davis, I appreciate everything you're doing. I know we have that case note project coming up, like in November. I just want to let you know right now, I'm not going to be doing that project. All right? Well, I could, under these rules, I suppose, just consider you withdrawn from the course, okay? At this point, well, that's a required element. Son, I'm sorry, that's not going to work for you not to do that. And so I could, at that point, consider you in breach, right, of your obligations, okay? And that's what happens in a contract. Why would we do that? Why would we allow, or even encourage, as we're going to find out, parties to let the other party know sooner that they're not going to be able to perform? If you need that coal to keep your power plant running, and you find out on Monday that Friday's delivery isn't coming, what do you have a chance to do? You have a chance to get somebody else to get you the coal that you need by Friday. If Friday comes and nobody has called you and the train just doesn't show up, you have no chance to get anybody else in there, right? Now, what we're going to find out later on is that if the original company calls on Monday and the power company is able to get substitute performance in time, then the original coal company, they get some credit for that, okay? It gets an offset in the amount of damages that we're going to hit them up for. And we won't hit them up for the entire amount of the loss. We'll just hit them up for how much more it cost us to get substitute performance. See the difference? Like maybe we were going to get that shipment for $1 million, and instead it cost us $1.2 million. But we at least got the shipment in there. Well, hey, it didn't shut down the plant, and we didn't have all this extra kinds of damages, so you know what? That's okay. So we're going to go and hit the original company for the $200,000 additional expense, not the whole cost of the deal. That's the incentive for people to let somebody know ahead of time we're not going to be able to perform. Okay? So the innocent party gets to treat the repudiating party as in breach, and go out and find substitute performance. You could imagine then in that scheme, if you've gone out and secured a second contract for somebody else to deliver the coal by Friday, and now the original guy calls back on Wednesday and says, changed our mind, we struck coal. I don't know if you can do that, but, we found some more, found another pile. And so we'll be able to do it after all. And if he could hold you to the contract at that point, now you got two trains coming in at the same time on Friday. That wouldn't work, would it? So that's why we allow them to treat them in breach, cancel it, and find substitute performance. It's better for business and operations. All right? Okay? Clicking along here. Discharge by agreement. This is where the parties decide this isn't working, or it's good enough. You know what? It's fine. No, it's fine. But we can't. No, it's fine. And we agree to walk away. We settle the case. In that situation, we call it mutual rescission. Mutual rescission usually is we're going to undo this one or tear this one up and just make a new one because we figured out, what we had down here just wasn't working as well. Let's do a new one. Let's say Maranatha has an agreement with Pioneer to do the food service. That's not a hypothetical. We do. And it's a 5-year agreement. And when we originally did the 5-year agreement, we had some estimates about what enrollment was going to be. And then 1 year comes along and enrollment triples, right? Well, at that point, we're going to go to Pioneer and say, hey, listen, our original contract wasn't thinking we were going to have this many students, and you could probably do a little better deal for us, right? Price-wise, if we have this, triple number, then we would agree to renegotiate the deal. The process of renegotiating is called mutual rescission. Did you ever wonder, when a football player, and it says he's going to try to renegotiate his contract, who was the guy? Was it Cam Chancellor was trying to do that this year and he held out? But the Seahawks, right, didn't want to deal with him. Why? Because he wasn't even in his last year of his deal. He's got 3 years left on his deal. So they did not want to set the precedent for every other guy to come in and say, I know I have a contract and everything, but I'd like to tear that one up and make a new long-term, more lucrative deal. So what they were trying to do there was mutual rescission. Did they have a contract? Yes. They just wanted a new one. Would the Seahawks have been required to redo the contract? No, and they didn't. And they played chicken for a while, and eventually the player caved and joined the team. Why? Because he wasn't going to get paid if he didn't show up. So eventually he showed up, he got paid, and they'll figure it out sometime. And you'll quietly hear about the Seahawks reached a new deal with Cam Chancellor for 8 years and $700 million or whatever they're all going to make. Novation is when we're going to switch parties. A third party is now substituting performance. Novation solves the problem of delegation that we talked about earlier. What was the problem of delegation? I'm still on the hook, right? Novation gets me off the hook. And guess what I need to get off the hook? I need the original party to whom performance was due to sign off on that. If he's willing to let me off the hook and he signs it, it's called a novation. And then finally, we call it accord and satisfaction. And this is where we're not going to make a new one, and we're not bringing in a third party. We're just walking away. We're done. It's enough. And in that case, you have to have some sort of a dispute going on. There has to be something that's being resolved. And we're going to settle up. All right, you know what? Where are we on this deal? What do I owe you? What do you owe me? Let's just walk away. And, you pay me $1,000 and we're done. That's called accord and satisfaction.